Hello students, the next chapter discusses the variety of matrimonial causes that are likely to arise in a private international law scenario. The chapter addresses the three issues of private international law: jurisdiction, choice of law and recognition of foreign court orders in the family law aspect of marriage and matrimonial causes in England and India. Matrimonial causes. The Matrimonial Causes Act 1857 repudiated the idea of indissolubility of the marriage and shifted the jurisdiction in matrimonial matters. It was transferred to the civil court. Further reforms followed up, culminating in the Matrimonial Causes Act 1973, supplemented by the Domicile and Matrimonial Proceedings Act 1973. English private international law and the dissolution of marriage. There are two grounds for dissolution of marriage under the English law: consent theory, irretrievable breakdown theory. Marriage is said to be irretrievably broken in any of the factual situations. The respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. 2. The respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. 3. The respondent has deserted the petitioner for a continuous period of at least 2 years immediately preceding the petition. 4. The parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the petition, and the respondent consents to the grant of the decree. 5. The parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the petition. Indian laws. Section 10 of the Indian Divorce Act 1869 recognizes only one ground of divorce available for the husband: adultery of the wife. The wife can sue for divorce on any of the following grounds: the husband had converted to another religion and taken up a second wife, has been guilty of incestuous adultery, or of bigamy with adultery, or of rape, or of unnatural sexual conduct amounting to offence, or of adultery coupled with desertion without any reasonable excuse for a minimum period of 2 years. The Parsi Marriage and Divorce Act 1936 has 11 grounds of divorce. Another archaic law, this legislation has categorized these 11 grounds under two heads: pre-marriage faults and post-marriage faults. Pre-marriage pregnancy and pre-marriage insanity are seen as grounds of divorce. Post-marriage faults include willful refusal to consummate the marriage, unsoundness of mind for 2 or more years, cruelty, adultery, rape or unnatural offences, physical cruelty, minimum 2-year desertion, and so forth. The Hindu Marriage Act 1955 lists 9 grounds for divorce, ranging from adultery, desertion, cruelty and conversion, and such others, to being infected with communicable diseases. Divorce under the Muslim law is largely non-judicial. The grounds are categorized under two heads: unilateral divorce by the husband and divorce at the instance of wife but with the consent of the husband. The right to obtain judicial divorce is available to the wife alone. Jurisdiction. Jurisdiction in matrimonial causes is based on two grounds: domicile and habitual residence. The Indica versus Indica decision of the House of Lords specified that English courts have jurisdiction to entertain a petition for divorce if parties are domiciled in England at the time of the commencement of proceedings. The Matrimonial Proceedings Act 1973 states that the court will have jurisdiction to entertain a petition for divorce if either of the parties to the marriage is domiciled in England at the commencement of the proceedings. Subsequent changes in the domicile of the husband do not affect the jurisdiction. Such court may entertain any cross petition for a different form of relief. For example, in a matter of divorce, the courts may entertain a cross petition for judicial separation from the respondent. With the Hague Convention adopting habitual residence as a basis of jurisdiction, there has been much legislative activity incorporating that provision. In India, for most religions except the Muslim and Jewish communities, domicile within the territory of the court confers jurisdiction on that court in matters with regard to divorce. Further, a petition for nullity of marriage can be presented only if the marriage has been solemnized in India, and further that the petitioner was resident in India at the time of presenting the petition. Residence is the general jurisdictional rule under the Hindu Marriage Act 1955. Domicile, however, acquired significance with respect to Hindus resident outside India. A similar principle is seen in the Special Marriage Act 1954, where domicile is considered only for Indian citizens residing outside India. Questions on residence are questions of fact. What amounts to residence have to be decided on a case-to-case basis. It has to be something more than a casual visit to amount to a residence of a person. It has to be a dwelling either permanently or for a considerably long period of time. Choice of law. Choice of law in matrimonial causes or disputes in England. If it is established that the English court has jurisdiction, it would be the English law. The Indian law states that the Indian court, having assumed jurisdiction in a divorce petition, would apply the personal law of the parties on the understanding of the principle of lex fori. Recognition of foreign court orders. Foreign divorce decrees, English law. English courts would not recognize a foreign divorce decree unless it was pronounced by the courts of the country where the parties were domiciled at the time of the suit. They would recognize a foreign divorce decree even though not pronounced by the court of domicile if it is recognized as valid by the court of domicile of the parties. Foreign divorce decree would be recognized if parties establish a real and substantial connection to the country of the court that dissolved the marriage. Non-judicial divorces in any form would be recognized in England if parties were domiciled in a country that recognized such mode of dissolution of marriage. Further, a foreign divorce will be recognized in England if at the time of the institution of the proceedings either spouse was habitually resident in the country where divorce was obtained, or at the time of the institution of proceedings either spouse was a national of the country where the divorce was obtained. According to the 1971 Act, the foreign divorce obtained in a non-judicial proceeding would be recognized if it was valid under the law of the country where it was granted. They would also be recognized in England if they were recognized under the personal law of the parties. It can be said that English law specifies that in a situation where either of the two following grounds is proved, the English court would not recognize the foreign divorce. 1. When there is a violation of the principles of natural justice, or 2. When recognition of such foreign divorce would manifestly be contrary to public policy. Indian law. The Indian law has ensured significant importance to considerations of natural justice in matters of recognition of foreign court orders related to divorce. In the case of Satya versus Teja, while dealing with a matrimonial dispute, the Supreme Court held that the challenge under section 13 was not limited to civil disputes alone, but could also be taken in criminal proceedings. In this case, a foreign decree of divorce obtained by the husband from the Nevada State Court in the USA in absentum of the wife without her submitting to its jurisdiction was held to be not binding and valid upon a criminal court in proceedings for maintenance. The Supreme Court in the landmark case of Srimati Nirja Saraf versus Sri Jayant Saraf opined that the Union of India may consider enacting a law like the Foreign Judgments Reciprocal Enforcement Act of 1933 enacted by the British Parliament under section 1, in pursuance of which the Government of United Kingdom issued Reciprocal Enforcement of Judgments India Order 1958. The court further suggested adopting similar rationale as English law with regard to the principles of natural justice, as was evident in the Satya versus Teja case, and also on the grounds of public policy. In India, the Law Commission in its 65th report recommended 1. The rule of domicile for recognizing the foreign divorce decree should continue, and such divorce granted outside the domicile country but recognized in the country of domicile should be recognized in India also. 2. Non-recognition of a divorce by a third country should not be a bar to the recognition of the foreign divorce in India. It is desirable to provide for the recognition of foreign divorces or legal separations granted by the countries where both the parties are habitually resident, or by countries where both parties are nationals, in addition to the current test of domicile. 3. Domicile of the husband attributed to the wife need not be applied in relation to recognition of foreign divorces and separations. 4. A foreign judgment of divorce shall not be recognized on grounds of natural justice shortcomings within the divorce proceedings, or if the judgment of the foreign court is contrary to public policy or is obtained by fraud. Any ancillary order concerning allied questions need not be treated as binding, even if the foreign decree of divorce is recognized. Recognition of foreign nullity decrees. English courts have followed the well settled rule of according recognition to a decree passed by the court of the common domicile or residence of the parties. It has also followed a practice of according recognition to a foreign nullity decree if it was recognized by the country of common domicile or common residence of the parties. The emphasis here is on the word common, as there have not been many instances of recognition of a nullity decree originating in a place that was a domicile or residence of either of the party. Hence, such recognition is doubtful. Once recognized, it ought to be taken that there is a declaration of the pretended marriage as a nullity, with each party free to marry again. Indian law on this topic seems to be founded on the analogy that since there is no distinction between matrimonial causes regarding jurisdiction, the Indian law on recognition of foreign divorce decrees should also apply to recognition of foreign nullity decrees. Recognition of foreign judicial separation orders. A decree of judicial separation obtained outside England and its territories shall be recognized in England if it is effective under the law where it was obtained, and at the relevant time either of the parties to the marriage was habitually resident, domiciled or national of that country. Recognition of foreign judicial separation orders. Indian law. In Indian law, it could be said that courts could apply Section 13 Civil Procedure Code to foreign decrees in matrimonial causes, including judicial separation orders. Enforcement of foreign maintenance orders. The Maintenance Orders Reciprocal Enforcement Act 1972 is the primary legislation under which the REMO process operates in the UK. In addition, the UK has agreements for maintenance enforcement with most members of the Commonwealth, with the Republic of Ireland and the United States of America. English courts enforce foreign maintenance orders. The procedure varies depending on which foreign court has made the order. Once registered in England, the foreign maintenance order will be treated as though English court had made it. Enforcement of foreign custody orders. In cases of custody orders, English courts have always been guided by the principle of the welfare of the child while deciding upon enforcement of foreign custody orders. In Re B settlement case, the Chancery Division, while deciding upon an application by the father for enforcement of a custody order from a Belgian court, allowed the child to remain in England, keeping in mind the welfare of the child as the main consideration. Enforcement of foreign custody orders. Indian law. In India, the Supreme Court in Surinder Kaur's case was hearing a custody application appeal by the mother whose child was withdrawn to India by the father. The court held in favor of the mother. It opined that jurisdiction is not attracted by the operation or creation of fortuitous circumstances, such as the circumstance as to where the child whose custody is in issue is brought or for the time being lodged. To allow the assumption of jurisdiction by another state in such circumstances will result in encouraging forum shopping. Ordinarily, jurisdiction must follow upon functional lines. That is to say, for example, that in matters relating to matrimony and custody, the law of that place must govern which has the closest concern with the well-being of the spouses and the welfare of the offsprings of the marriage. Similar rationale was adopted by the Supreme Court in the recent judgment of Suryavadanan versus State of Tamil Nadu. It ordered the parent who took the children out of the custody of the foreign court to return back to the foreign court's jurisdiction in fulfillment of the interim interlocutory order of such court. The Supreme Court stated that the foreign court of competent jurisdiction is best positioned to address the issue of the welfare of the child, as it has the closest connection with the facts of the dispute. Hence, the appeal was allowed and the mother, a British citizen of Indian origin, was asked to submit to the foreign court's interim order and return the children, British citizens, to the protection of the foreign court. The Supreme Court further opined that its judgment is fit in the circumstances, as the mother, who has earlier withdrawn the children from the UK, had all the opportunity to contest the interim order in the foreign courts. To conclude, we have discussed matrimonial causes within this legislation and the various laws that could be applied to them. Foreign matrimonial causes are subjected to jurisdiction of the local court, either on the basis of domicile or habitual residence. Further, the courts have shown inclination to recognize foreign courts' orders in matrimonial causes if such foreign courts have validly made such pronouncements upon ensuring that they had jurisdiction to do so.